ABC Gold Coast.
You're listening to Sarah Cumming.
Victim survivor advocacy groups say delays in Queensland's DNA testing labs are increasing pressure on already traumatised people. This is something we've spoken about on the program recently. Major delays, incorrect testing methods have been uncovered in reviews of the beleaguered Forensic Science Queensland Laboratory. Well, a prominent Gold Coast criminal lawyer has called for a Brisbane-based program for cases affected by these issues to be extended. The current DNA-affected case call-over for matters that need retesting or are delayed due to these backlogs doesn't extend to the Gold Coast or regional areas outside Greater Brisbane. Solicitor Ron Behlau told the ABC's Alexandria Utting this means some current cases being heard in Southport have been subject to years of delays with no timeline for when crucial DNA evidence will be tested.
The genesis of this debacle really relates back to the former Labor government holding a commission inquiry in 2022 into forensic DNA testing in Queensland. There was a second inquiry in 2023. Both inquiries revealed systematic and serious issues into forensic testing of DNA and its use in criminal cases across Queensland. The current Christoforley government rightfully has engaged leading experts such as Dr. Kirsty Wright. The most recent report released earlier this month has made some damning findings of contamination, unreliable results and testing delays, which has had significant impacts on both victims and defendants. Current government has pledged $50 million for a 2-year program to address the DNA backlog by outsourcing thousands of DNA samples. They've also pledged $6 million to the Director of Public Prosecutions to assist them with this DNA debacle, and again, we applaud that. However, I have serious concerns about the courts themselves being hamstrung to address active backlog DNA matters.
As part of this solution to the problem, there's been what's been called a DNA affected case program that's been set up in Brisbane. There are some concerns that you hold about how that will impact the Gold Coast and if people who need reviews on the Gold Coast will actually be part of it.
It's clear from this report that there are two types of DNA affected cases. The first are DNA cases which are backlogged requiring retesting. The second are active DNA cases which are currently before the courts but are being significantly delayed. It's the latter that I'm really concerned about, being a practicing lawyer on the Gold Coast. And what we say is this: the practice direction was produced back in December 2024. That DNA case affected program deals with only 12 courts in Queensland. We know that there are 100 magistrates court locations in Queensland, and what that means is where there are cases which require DNA reports and require us to have those reports in order for them to be advanced, there are only 12 courts in this state, 12 areas in this state where those matters can be dealt with. We're calling for, that is the submission that myself, co-authored by my partner Jason Murakami, lecturer Lynn Weathered and Professor Janet Chaseling. We have urged for the expansion of that practice direction. We say it can be done through the use of audio-visual links, and we did that during COVID, and we did that very successfully. Practitioners and prosecutors and courts, I was capable of appearing in regional northern Queensland for matters. And so we say we did that with great success during COVID. Why can we not now apply that for this DNA debacle? And I also know that our New South Wales counterparts have adopted full AVL bail hearings for practitioners across their state. So it's being done elsewhere. We know it works and we know we can do it. It's just that we haven't expanded this practice direction to allow for that to occur.
And that would mean that in those 12 regions that are having, ability to look at the affected cases, you'd be able to get them to consider a Gold Coast case and then appear in their court. Is that how it might work?
What we have suggested is that the Brisbane be the central location, and so that if there was a case that was DNA affected on the Gold Coast or in northern Queensland or in the regions through Queensland, we would apply for the matter to be moved to the DNA affected case program and to be dealt with there. And if it meant that we had to appear by AVL, we would do so. If it meant that prosecutors would need to appear by AVL, if it meant that forensic experts would need to appear by AVL, we would do so.
And so in terms of what that affected unit is doing, is that in some regards sort of taking away restrictions that might be around criminal matters, I guess, in terms of timeframes and things like that? Is there a bit more flexibility for those cases that are involved in the backlog or being retested?
Yeah, it most certainly would. I mean, there are examples at the moment in the regions, in the northern regions and even on the Gold Coast, where we have been waiting for 3 years. And that means defendants are waiting for 3 years. In the lower courts, complainants are waiting for 3 years. And that has a really detrimental effect on the criminal justice system. I mean, what that means is people's memories can fade, the faith in the justice system is eroded, and in some instances, defendants are being granted bail because they're sitting in custody for periods longer than they would have jail terms imposed.
And in terms of how DNA is relevant to criminal matters, I guess a lot of people think of DNA as being, say, only for a major crime, like a murder or something like that. But how important is it in general when it comes to, building a defence for someone or the other way, I guess, trying to prove something against someone?
Yeah, look, DNA isn't the panacea that some people think it is, but it is still important, and it can be an important prosecution plank if they're trying to identify whether a person was at a particular location or their DNA is on a particular item. So I think it is still critical. No one's suggesting that it's not important evidence. What we're really saying is these backlogs and delays are affecting current cases that shouldn't be backlogged. Yes, we've got this issue of the older matters, and again, we applaud the government for allocating resources to get through that backlog, but we want to make sure that the current matters before the courts aren't being delayed. I mean, when you think about it, if a matter has to wait for 3 years in the magistrate's court at either the regions or on the Gold Coast, that means a trial for a matter might take up to 5 years. And that's just extraordinary.
Solicitor Ron Behlau chatting to the ABC's Alexandria Utting on ABC Gold Coast mornings, 24 minutes to 10.